Well, obviously there is a background in the from the next room, and I don't think we will be able to get across, but I'll try to speak a bit more loudly. Let me tell you a few more words about our session today. Let me explain how we decided to hold this session, and then I will introduce our speakers. The management of investment projects is an area that we have been involved in for about 30 years. This is one of the key instruments to implement various construction projects, and many construction companies use it, and not only construction companies use it. I noticed that in the past 4 years, construction was mentioned in passing, but never specially, even though each of us, to a certain degree, was involved in real estate. We buy and sell apartments, we take mortgages, and then I'd like to thank the organizers for setting up this specific session, because we're going to talk not only about construction projects and investment projects, but also about the legal aspect of these projects. We have all kinds of projects in different stages, starting from development, preparation for sales, etc. There are a lot of different aspects that require legal assistance, including obligations, land, material law, etc. And over the past 10 years, we accumulated a lot of experience of legal support to these construction issues. It's a very big topic, and I suggest we narrow it down to the most relevant issues. Therefore, we invited legal practitioners from large construction companies to come and talk to us. We also invited a representative of a consulting company which is involved in large investment projects, including construction projects. And in order to have an external view, we also invited Karim Rashid, a famous architect and designer, so that he was able to give us another perspective, take into account international experience, and that is especially relevant because our legal forum is an international legal forum. We also have representatives of the banking community in order to discuss the financing issue. I believe that the problem of the 17th of December is still very relevant. It's very high on our agenda. I would like to give the floor now to Igor Perivoshikov from the Gazprom Neft company. It is involved in many large-scale investment projects. He will tell us about the issues that his company faces in implementing such projects. He will give us a legal perspective. Good afternoon, colleagues. Let me begin by saying that a lot of companies are involved in large construction and investment projects, and there are a lot of issues that are quite relevant. Our company sometimes makes me doubt which area is our core activity. Are we more involved in construction projects, or are we more involved in oil and gas? I hope that my presentation will be put up on the screen, and I will be able to show to you the range of various projects that our company supports. We are involved in many different construction projects, as I said. The construction projects are connected with refinery manufacturing facilities and terminal construction and shipbuilding construction, and we're also involved in a large development project for the construction of a big business center, which is known as the Lakhta Center, as you all are aware. So you can see the range of issues that we may face, and indeed we face very different problems here. I tried not to focus too much on the problems that are relevant to our company only, I wanted to give you an overview of various problems that may be of interest to other companies that work in the sphere of energy and construction. So my first preliminary conclusion is that we have a lot of common areas of interest. And one of the issues is related to placing contracts. And one of the specifics is relevant for the extracting industry. The signing of construction contracts while the design and working documentation is not yet ready. Well, there is a certain business logic behind it. Business companies are trying to save time, trying to place contracts as early as possible, while the design and working documents are not yet ready, and there's no understanding at the beginning of what is actually going to be built. That is obviously a very difficult decision, and it's a headache for us, because nobody understands what is the subject of this construction contract. We have never had a big case whereby a contract would be deemed void based on the misunderstanding of the subject of the contract, but there are a lot of different unresolved issues. The fact that the subject of the contract is not very well defined leads to the fact that the estimate is not very specific. And when it comes to the price tag on the contract, we have to use all kinds of strange methods that are close to methods used by shamans. Obviously, a gas processing center built in Siberia is hardly comparable to a center or complex in the Middle East. They are maybe similar, but they are still very different. And therefore, in the end, you get an escalation of the costs. In addition, you get all kinds of changes that you want to implement, and the changes are based on the fact that the parties did not understand each other or did not know what they were talking about at the very beginning. So they apply to legal assistance. They want to have legal assistance, and then you get into the arbitration in order to resolve various conflicts arising from the construction contract. It would have been possible to use various expert assessments, but in our country we run into a number of problems here. The existing type assessments are very difficult to apply because a lot of manufacturing facilities are unique, and therefore the documents that could be potentially applied for the estimation of the overall costs would not take into account a lot of specifics of such facilities. Plus, the document that could potentially be applied, as I said, was developed in 2001, and we're now in 2015. I think it would be interesting to apply the experience of Great Britain that publishes the construction reference material, where various costs are indicated, and every year additional lines of work are added to this reference document. A number of documents may arise from the lack of working documents at the stage when the contract is concluded. Often the ordering customer finds it difficult to understand the documents because of the lack of experience. So a way out could be to establish specialized organizations that could provide consulting, assessment, and conduct an acceptance procedure. But even an expert organization would not be the end customer. And it might be difficult for the end customer not to put certain pressure on this specialized organization. Because the specialized organization would definitely, even though it might be an independent organization, be inclined to take the side of the end customer. Another thing I wanted to say is that large-scale construction projects, especially international projects, make it very difficult to take the cases into the court of arbitration. Because there are a lot of things that are sort of buried in the construction projects. It's very difficult to determine when exactly a mistake was made, who is to blame that the project was delayed. We try to take all of such issues and resolve them before the case could be taken into the court of arbitration. We try to involve independent experts. We try to settle outside of court, and then when the preliminary issues are cleared, then the case could be taken to the court of arbitration. The second topic I wanted to mention in my presentation here is the issue related to the application of other countries' law, foreign law, to international construction contracts. I hope that you, as my colleagues, would agree that we as Russian lawyers may prefer to structure deals related to large-scale construction projects under Russian law. If the construction project is built in Russia, in most cases it is built with Russian money, it is definitely going to be operated in Russia, and therefore all the benefits as well as disadvantages related to environmental risks, etc., would remain in Russia. So it would be preferable to structure the deal under the Russian law. But the problem is that the construction of manufacturing facility in such projects, the law is secondary to the overall economic environment. This is not the first forum where we try to discuss the issue of how Russian law could be more interesting and more accepted by the Russian legal community, but this is not going to happen until complex industrial facilities would be built with the help of foreign instruments and legal mechanisms. Let me give you an example. For example, we need to purchase a technology which is not available in Russia. Either we have a similar technology which is outdated, or we don't have it, and then we buy a license for a technology. The company selling the license may be based somewhere in the state of Connecticut, and they are not interested in discussing possible changes or even the use of Russian law. They may have never heard about the Russian law before. They only heard about the Russian law for the first time when you applied for the license. But okay, the license is not even the first step. License is just a small step in terms of the large-scale project. But when it comes to the implementation, you have to have a licensed organization or a subcontractor that would, in most cases, be hired from the same country where the technology was developed. And then a number of questions arise. What company do you want to use in order to develop the FIT? Russian companies do not have enough experience. Other companies may not have the expertise to take the design documents through all the necessary steps in Russia. So when you get a foreign design organization, you get a list of equipment which the designer believes is the best for the project. In most cases, this is the equipment manufactured abroad. And now again, you get into this set of equipment which needs to be purchased abroad. then you have to choose the general contractor, and by that time already you have so many foreign elements that you decide to structure the deal under the British law, for instance, rather than under the Russian law. In the end, and sorry, I forgot to mention also that there's one more addition, one more complicated element: foreign funding or financing. It may be a syndicated loan from a foreign bank or a credit under the guarantees of an export agency. And that means that the entire deal will be regulated by a foreign law. And that means, among other things, is that you have to use a format that is more convenient for foreign companies, but it is definitely not the kind of contract that is acceptable and is widely used in Russia. And then again, you go into financing, you get into banks that usually serve the contractors. Then the foreign law is chosen as the regulating law. The arbitration would definitely be not in Moscow, but in most cases one of the most widely used courts of arbitration abroad. Mediation would in most cases be based on those partners that are well known to your contractor, and you would in any case need to reach a compromise. So again, it's all structured under the foreign law. And a final topic I wanted to touch upon today, which is of great relevance to us, is financing. Both by Russian institutions and foreign institutions. And this often stands in the way of attracting funds for large construction projects. I'm talking about the misunderstanding or lack of understanding of what the project is all about by the construction company and by the financing institutions. The problems often arise from the moment when the contract strategy is selected. The contract is used to specific methods. For example, all the construction phases are separated into key elements with the use of key contractors for each stage. And then when the contractor gets into the bank says, we do not understand this mechanism, we do not understand this schematic, I'm the one giving the money, I don't understand that, so can I please see something that I will understand? In other countries, this is not really a problem, because even FIDIC emerged as a format that was developed with the help of the World Bank, because it was a format that was developed specifically for construction projects. There's another format, MDB, and to a certain degree, these formats answer the questions that may arise from different parties. But in our case, in our format, we still have a lot of unresolved issues. And again, the final issue I wanted to touch today is the sanctions, how the sanctions influenced the financing opportunities. Yes, there was an influence, there was a great impact. In some cases, there was a direct impact. Some companies were put on the list of companies under sanctions, and therefore foreign financing cannot be attracted. There are other aspects when direct financing is not forbidden, but there is an indirect influence. The entire Western world gets the impression that people do not want to get involved with Russia. Just like Russian historian Khrushchevsky wrote that an enormous effort is required in order to get involved. And I'm sure that a lot of foreign institutions, Western institutions, need to add an additional pressure or make an additional step in order to agree to funding projects performed by Russian companies. So some of the projects had to be abandoned, such as offshore oil and gas production. Some had to be limited, and companies are so afraid of compliance that they don't want to work with Russian projects, because even though there may be no direct ban. So, as you can see, there's a range of problems, and we are rather optimistic about the possible ways of resolution. A year ago, when I spoke at the forum, the legal forum here in St. Petersburg, I mentioned a number of problems in the civil legislation. The civil legislation problems that stand in the way of implementation of large-scale construction projects. The problems that make partners use other laws. But I have to say that within this year we have seen a great progress, and I can wholeheartedly recommend to use the Russian law to structure your construction project deals. So we can see that the problems we raise here are being solved. And in many ways, these are not the issues that we touch upon here, are not the issues for our community, because our community is always ready to do everything in our power to resolve these issues.
So you have structured the deals under the English law, and just the contractors and designers are foreigners. And what are you doing now when, due to the sanctions imposed, they should cancel their activities? So how do you envisage your legal just relief here? Dennis is absolutely right in that our outside experts have developed a certain package of quite effective, if not panacea, mechanisms targeted against the sanctions effect. However, these are mostly just actions taken in response at the level of the contract with our counteragents. If we were to give some more general effect on our business of these sanctions, they did not touch upon all our spheres. Where we cannot do that any longer, yes, we stop and sit and wait till better times come. Where the sanctions are not directly negatively affecting our activity, or just where the partners are just trying to be preemptive in terms of their risks, which might be illusory, we just find some other partners and just we try to explain to the partners which refuse to continue working with us without good grounds. So when in the better times, which are sure to come, probably it will be problematic for them to restore our relationship and come back to cooperation. But 5 years ago, that was quite a topical issue in terms of the connections legislations and energy legislation, and the kind of the balance related things. And then asked Dmitry Timofeyev from Rosvodokanal to talk about it. Good afternoon, dear colleagues. Thank you, Victoria, for providing me the opportunity to address the speaker during this panel. I would like to start with a little disclaimer. I came here to talk about quite earthly, as compared to the sanctions and attracting finances, issues that are part and parcel of management of construction projects. if we stick to the topic that was announced for our panel, I used to work for a construction company before I came to work for the canal. So I remember very well that the project was deemed completed and management of it was deemed successful when an apartment house was successfully built, successfully put into operation, and all the apartments sold. I don't know if this has changed since then. No changes. So there are sanctions now. There are problems related to funding and financing. However, if you don't have a water connection, you wouldn't be able to finalize the construction, go through the acceptance and sell apartments in this estate. So I picked up two major problem areas relating to the project management process, preparation of the design, project documentation, and the document approval. And since we are having a legal forum here, the legal dimension of it. So construction and sewage and water supply issue are quite specific. I will try to abstain from very specific industry-related abbreviations or terms, and I would like to apologize to the interpreters and the listeners if they find it problematic to translate and understand this specific terminology. So let's focus first on how much water there should be in an apartment house. So what is the design load on water? So I'm sure that we all here deal in construction. If you're not from the field, so you might be interested in why you don't have any water supply in the apartment which you just bought. So then you will be more knowledgeable about what and how this can happen. So now about the mechanisms of calculating of the design volume of water per one apartment house. So the connection of the capital projects under construction to the water supply and sewage is done under the connection agreement, and there should be a connection fee paid, which is a source of building up the services and hooking up this apartment house to the water mains. The fee, there were many changes in the governing legislation, and beginning last year, the connection fee comprises two parts: the distance-related fee. So just this is the pipe running through the mains to the building. The last mile fee, and the head, so that the water can reach all the upper stories and shouldn't stop on the third floor. For construction companies and for us as operators of such strategic resources as water, what does this mean? The current legislation stipulates two ways of calculating the design load. The problem here is that each of these two methods contains very different formulas which might entail completely different outcomes. The method one is based on the following. So the head of this kind of the power of the water. It depends on the number of residents to be living in this apartment house. So the number of apartments is multiplied by the family-related ratio, which varies from city to city, from region to region, and the living space is divided by a certain quota per person in the family. So in the design documentation, in different regions, one and the same construction company uses different formulas and has different outcomes. So we, as water supplying operators, sometimes do not understand what exactly we have to construct. Another problem is that the design document is kind of floating. It can undergo a change, and when people approach us for the connection terms of reference, we're basing on one set of projects, design documents. So when it comes to the occupancy stage, so the number of stories changed, or the number of flats has changed, and we have only 18 months to complete the construction according to the current legislation. So we would have been ready to change the structure to meet the new requirements of the developer, but the pipe has already been laid, and in order to increase the capacity and just to increase the head, we need to basically do things over, to lay another pipe next to the first one and to enter into another connection agreement, which is impossible. So it comes to a dispute as to what we should do in such situations. So we request a change and approved projects according to the established procedure, and we'll recalculate the connection fee. Not all partners respond to this request, and it entails another legislation-related issue. So I'll have some notes here. So there is a certain regulation that contains requirements to the design document, and is, for example, including the balance between the water supply and sewage. So we are responsible for cold water supply and sewage, and the balance is not requested there. So on the one hand, we cannot construct without the data that this balance encompasses, and we cannot amend our investment program accordingly in the absence of the design document. On the other hand, according to the rules, we are not in a position to legitimately request, legally request, the developer to provide this information. So the court practice varies. Our company works in 7 regions, and in some of them the courts are on our side, so they follow some common sense principle. In some other cases, they say you have been provided relevant information, you have to do things over. However, they forget that if we do things over, somebody has to pay for that. And if we cannot change the connection fee, so then we have to do it through tariffs and just to reshuffle our expenses from the current maintenance to subscribers, which is not good. So now we are working to amend the rules that we are governed by in providing cold water supply and sewage, so that we can unify the practice. So our position is that the developer, if there are some changes in the constructed project, has to provide the amended and updated project, and it has to be approved by all the necessary authorities as if it were on the initial stage. So providing water service and supply to citizens, we are happy to cooperate with the construction companies and move forward in this field. The second issue I wanted to raise during this panel discussion is as pending and relevant as the first one, and it has a direct effect on the economy of the construction. So the connection point identification. So this is a location to which we have to bring the pipe from the city mains, beyond which it falls under the responsibility of the construction company. We also have some challenges there. According to the current legislation, we have a general norm that the connection point of the capital construction project is identified in the connection terms of reference. So this point is marked on the water mains and services of the city, and this is an appendix to the connection. It's good that I haven't swallowed it. So the problem here is that the legal framework in relation to the connection point vary. So if we address the law on water supply and sewage, it is quite clear in saying that the connection point has to be located on the construction project land plot. Sounds quite straightforward. However, in a standard agreement for connection that we need to enter into with all the clients, it is written the opposite way. The connection point is to be located at the border of the service, which is in the construction, which is in the apartment house. So these are two different stories. One thing, it's in the house itself, or it's a point on the territory of the residential estate land plot. So it's either construction company has to incur high expenses to finalize the construction, or us ending up investing more in this construction project. So a conclusion here is that we have a collision between the laws. So what we're doing now, so the legal norms a priori have priority legal force versus governmental regulation. So we bring our services and networks to the border of the construction plot. And if we were to bring into the house, it's a different thing. So in order to develop our core business, which is construction of residential estates, so we're now working to amend the governmental regulations that approve of the standard requirements to include the border of the land plot as the major location of the connection point. I'd be very grateful to you, construction companies, if you also partake in our effort. Question, so just the pipe that you bring to the border of the construction land plot, if you were to be successful in the amending the governmental regulations, so how are you going to construct it? What are you doing now? Now we are constructing it and giving it to the energy company. I don't know what the situation is with the energy companies, but with water supply, if we speak about concessions, if it's a private operator, then this network has to be put on the city balance. It has to have the title of ownership, and it has to be part of the concession agreement. Otherwise, we wouldn't be able to operate. We have to operate it in a mandatory way, but we incur face the risks because we don't know who this property is owned by, how it was constructed, whether there were some faults and defects during the construction process, and it's more problematic to become responsible for that. So you are obliged to do it, right? Yes, it's mandatory. For the canal is a guarantor organization for the city. It means that we cannot deny that. There is no technological link is the only good reason for that. It's for some very wild construction projects when it is built in the middle of nowhere and just a big residential estate is being constructed without any proper permits and approvals, so then we will fight to the end. However, I hope that in the room these are construction companies of that kind. Of course not. Were there any discussions? Because basically it entails a higher price of square meter per the end customer. Were there any disputes? And what was the result? There were a few disputes about the connection points because major developers, before the construction is started, they come to agree things over and just we delimit our responsibilities. As to the design load, we have plenty of disputes. As a person who once worked for a construction company, I understand very well that sometimes the construction has begun without all the proper documents in place, so it entails variations in the number of stories in the building and many others. So speaking from a different perspective now, working for Vodokanal, I realize the fact that there is a problem, and the problem is not only if we have a smaller pipe. The problem is that if we have a bigger pipe, so that means that we used just excess amount of money, and we have to correct it somehow within our economy. So there are many disputes about this, but the practice is very different.
For example, in Omsk and Tyumen, we have had precedents in favor of Vodokanal. In the south, everything was in the other way around. What about federal cities? We're not represented in the so-called federal cities. We would like to be there, so I can't answer that question. Well, we will support you in your first initiative, but I don't know about the second one. Well, let's agree to disagree here. Thank you very much. Hello, I'm Alexander Maslov from Nizhny Novgorod. So this is a resource company that described the situation from its own side. Law 214, funds can only be spent on the construction and on the connection to the network. If it comes to utilities, the boundary is actually at the entrance to the apartment house. Now, you want to represent the interests in such a way so that the boundary was at the end of the land plot. And so this last mile between the end of the land plot and the house itself, all this work has to be covered with the funds which doesn't come from anyone. It's not possible to use the funds collected from the people under this law 214, and it cannot be used from other sources. And so a paradoxical situation arises. Nobody quite understands who is the owner of this piece of the pipe. We had real cases when the company said, well, here is a pipe between the house and the boundary for water canal. We don't know who it belongs to, although they were the ones who installed it there. Can you please take it on your books? So my question is, now if you look at the overall picture, what do you think about this situation? Thank you for your question. Let's now talk about the connection point. Now, there's law 214, but there's also a law on water supply. And it is said there that the connection point is at the boundary of the land plot. That's why I keep saying that we need to coordinate our efforts. We have to agree. Let's agree what is it that we need. We try to solve this issue in a systemic way. Now, in terms of who owns this piece of pipe, this is the issue which is probably the most relevant issue among all the issues that we have to resolve. And let me explain why. Why is it that we are so reluctant, or at least we're very careful about taking these pipes on our books? First of all, we have to take such pipes onto our books. We have to take ownership, but there are risks. Let's think not about our organizations, but rather the people who live in these apartment houses, people who live in houses. They are your clients and they are our clients. So in a situation where you have a pipe that doesn't belong to any organization, this is a pipe under the ground, how can you check what kind of pipe it is? What is it made of? What is the volume of water that can go through this pipe? Is that actually enough for this house? It's impossible to do that. In Omsk, we had a situation. No, I'm sorry, it was in Voronezh, not in Omsk. So we had a situation when a developer first received documents to build 4 houses, but in the end, they decided to change the plan and they built 6 houses. We were able to build the network in 18 months in accordance with the contract, and it turned out that the sewage pipe was okay for 4 houses, but it was not enough for 6. And of course, the pressure in the pipe, if it's not enough, then clearly it will be not very good for everyone involved, let's put it this way, including the environment in general. So we understand this approach from the point of view of the developer, that they want to increase the number of sites, they want to increase the number of houses, but at the same time, it's not clear what do we do about it. And the city administration has a different problem, because the city will have to take it on its books. It will have to either use a concession agreement then, or give it over to the local municipal authorities. So it turns out that the city administration doesn't have enough money to actually register this pipe as a pipe that would be in their ownership. And so this pipe basically hangs in the air. And let me be very subjective in what I say, but I think it's the supply organization that suffers most. Because when there's no water, where nobody really wants to get into the details, people go directly to the service organization and file claims. So we work in Barnaul, in Tyumen, in Krasnodar, in Tver, and Orenburg. If you are present in those cities, we would welcome a cooperation mechanism. We want to get engaged in a dialogue. We now try to build an algorithm for the city authorities so that everything went smoothly, but we would be very happy to see partners here, because it's not only about our profits, it's about our clients, and it's very important. Thank you for your attention. I have a question, or rather a comment. Now, you gave us a lot of reasons explaining why is it that it's best if you are the ones who build the pipes, the whole network, because it doesn't matter for you whether it's 2 kilometers or 2 kilometers and 50 meters, because you know what it is all about, you know about the technical requirements, etc. So, you and the developers are in fact interested in having cooperation, because the developer will pay for this last mile. Well, it's all about management, it's all about managing your construction projects, it's all about how you develop your land plots that were allocated for development. It's not just the apartment houses, it's also kindergartens and hospitals and everything else that you have to build. But you build buildings, and in between these buildings, somebody has to take care of the pipes. Now, if it's Vodokanal, if it's the water supply organization, then please let us have access to your documents before you start building. But you don't do that. Well, actually, the developers are quite interested in having all the details agreed upon even before they start building. That is, if they have all the documents in place. It's not just about agreeing on things. It's also about becoming part of your project. Oh, you mean you want to be a subcontractor for this particular part? No, we can't be a subcontractor. We can just ensure the connection. For a fee? No, even for a fee. We can only connect you. I think, in my view, it's a technical issue. Let's put it this way. You build houses. One house, second house, third house. You have cranes, you have a construction plan, you have a number of activities that you want to perform one by one, and then you have a different organization barge in with their own cranes, with their own construction plan. How do you arrange that? Well, if you have a construction site, you can have several subcontractors working at the same time. It's not technically impossible. Okay, let's then work on the standards. Let's discuss. Let's arrange things. I like this discussion. I like this discussion with the consultants. Well, I'm a developer. Let me tell you this. It is a problem. It's definitely a big problem. And it seems to be a trivial problem because it's just one pipe. And we as a developer can build this pipe, but what are we going to do with it? How is that pipe to be serviced? What is the justification for servicing this pipe? So it's either part of the building, and then the question arises, how do you zone this area, and how do you sell apartments, or we leave it with us and then somehow get the transfer of the title to the city. St. Petersburg and Moscow, Vodokanal, the water supply organization, is a government organization. It's a state, a unified company. And therefore, it is possible to transfer the ownership, and there's a legal framework for that. Then, when you start resolving this issue, there are ways, but we support the the idea that the boundary should be at the house. And I really find this discussion exciting because I'm very excited about the fact that we are discussing all these very, very relevant issues, burning issues, to say the least. Oh, I wanted to say something, but it somehow disappeared. I don't forget what I wanted to say. Oh, I remember. I remembered now. I think now you understand why is that some of the new houses that are built cannot be commissioned because there's no water. This is the explanation, because the pipe is not there yet. So yes, that happens. Well, I understand, because there is a collision between the government resolution between the federal law. So it's all about practical resolutions. But we have a legal forum, not a construction forum. So we are all talking about the legal aspects of the matter. Colleagues, I'd like to budge in with a quick word. One of the clients of mine, it's not a construction company, it's an oil company. It's a foreign company. They faced a problem whereby there were a lot of subcontractors on the construction sites. They had people laying pipes, they had people doing some other construction works, and they introduced a big agreement between all the subcontractors, which was called Peace on the Construction Site. It was an agreement that regulated all the possible conflicts. There was the indemnity method used. It's called Peace on the Construction Site. It's a very nice name. I don't know what's happening in Russia, if there's any special word or title that you can use for a similar document, but they call it that way. And of course, they use the word peace in terms of the lack of war, because in Russian this word can mean different things. It's the same word is used to define peace, but also the world. Well, construction doesn't exist without banking, so let me give the floor now to the representative of a banking community. We all understand that banks are usually involved at the financing side of the matter, and this is a very important role. So I would like to hear why banks sometimes withdraw from projects. I know also that banks are very involved in mortgage crediting and in housing credits. I'd like to give the floor to Ms. Safronova from the Sberbank of Russia. Good afternoon, colleagues. I'll be very brief. Since we are moving towards more practical matters, let me give you a very brief overview of the role the banks play in financing construction projects. I represent Sberbank, this northwestern bank of Sberbank, and we work in the northwest of Russia with the exception of Nenetsk, Komi and Arkhangelsk. So it's not the entire northwest of Russia, it's a smaller territory compared to the northwest federal region. My colleagues mentioned a number of issues with financing and loan taking earlier. I'd like to give you some examples of the kind of projects that we finance today. We've almost reached the 100 billion rubles of investment in various construction projects. It's 98.1 billion rubles. 10% of these funds were used to be invested in housing, residential buildings, and about 60% is financing for office buildings and shopping centers. The share of office buildings is gradually growing. Last year it was approximately 50%. Now we have reached 60 and more, closer to 70. Residential buildings is only 10%. So now let me explain what exactly we do in this sphere. Everyone who ever had anything to do with Sberbank knows that we have a very good regulatory base, regulatory framework, and everything, all the elements of the credit-taking process are regulated. In terms of financing residential buildings, we have a certain practice in place. We usually have an agreement with the developer committing to financing apartments in new buildings using a facilitated procedure, and we call this mortgage plus procedure. I think everybody wins in this situation. It's a win-win situation because we review all the developers' documents. That means that we can produce all the documents for specific mortgages quicker. Then there's an additional advertising channel for the developer. And people who apply to Sberbank for a housing credit or for a mortgage realize that the participation of Sberbank adds credibility to a construction project. And for us, it is a very good situation because we have an extended pool of clients. Our legal department, and we are here at a legal forum, so let's talk about the legal side of the matter, and I am representing the legal department here. I'd like to say that the legal department plays a very important role in making banking decisions about investment into construction projects. Whenever we review an opportunity for investment, we, as Victoria said earlier, create a special working group. Usually this working group involves the legal department of Sberbank, the developer legal department, and other departments are involved, and all the documents are examined. The lawyers are mostly interested in permissions, licenses, different documents that prove the ownership of land. They look into the solvency of the developer and other partners. And as you understand, there may be all kinds of partners involved, including the organizations providing guarantees. So this is normal legal work which is performed every time an investment opportunity is examined. The question was asked whether there is a special algorithm, and I can tell you yes, we have an algorithm for such work, but the legal work here is of a more creative nature. You are all lawyers here and you understand that sometimes it's difficult to determine the exact powers of an authorized person who will sign the deal, and that's where you have to be very creative.
So while financing construction projects, banks have quite modest amount of problems. There are some kind of lien problems when the funding has not been repaid. So we take just property rights as a collateral, and this might entail this lien problem. And recommendation to you as to people who approach banks is that it might be a wrong message to say that interaction with the banks in terms of funding is we are not welcome as clients. So we are very happy to see you, but oftentimes you come to the bank to ask for loans without having all the proper documents and construction permit on hands. So our colleague said that before you get the right title to the land plot and construction permit, and we need to ensure just the correct procedure of this so that we could provide you with the efficient credit services. And from our perspective, I would like to ask a question about the project financing. If, for example, a developer has a land plot, has no design or layout documents, and he wants to spend the year getting all the necessary approvals, but he needs money today to move the process of preparation of the layout, design documents and other things. So what is the collateral of such loan if you have this practice at all? I got your question. Thank you for that. This is quite a common situation, and we need to distinguish here between two things. If you come to ask for a funding for a construction project, the bank has to review the project, which is backed up with the construction permit and the layout plan. But if you call it not the funding for the construction project, but for example funding for an investment project or some other type of project, then we have some alternatives when we can review the application without the building permit, only bringing the land plot property title. We're trying to be quite flexible and offer standard loan packages to our customers, or we can negotiate different ways of funding. So if we speak about collateral, so for example, the collateral is a land plot, then he got the building permit, and then he started selling within the Federal Law 214. Then something happens to the creditor, to the so this is one of the problems that arise when you follow the Federal Law 214. Then we take a property title for the land plot as collateral, and the developer is working and begins to sell the apartments to physical entities within the framework of the Federal Law 214. So they enter into agreements. The developer does not approve the situation with us, so when the construction is finalized and as we go to register the collateral, we see that we have no collateral. This situation arises quite often, and we spoke with the city authorities and the registrar, but this is a problem that unfortunately has not been efficiently resolved yet. Can I also ask a question? I understand that many of the borrowers they don't have the title to the land plot, they lease it. How can a bank minimize the risks so that the lease agreement can be terminated unilaterally by the leaseholder, just lease provider? So how can a bank, what can a bank do to minimize its risks? So thank you for this question. The bank does not minimize its risks apart from an effort to just synchronize the loan of the credit agreement and the lease agreement. And the potential lease termination at the initiative of the lease provider cannot be dealt with in any possible way. So we do run a certain entrepreneurial risk in this respect. And during the validity of the credit loan agreement, we as a bank monitor the financial status of the borrower. in even a single non-payment of the lease will come out after this delay, and we'll start working with the borrower so that it does not evolve to become a second failure to pay, so that there is a threat of terminating the lease agreement on the initiative of the lease provider. So this is risk minimization tool, which is called the monitoring in the period of validity of the credit agreement.
In New York, you might want to. Do you want to put the headset on? In New York, to go to a bank and to get a loan. You all set? Sorry, I don't speak any Russian. Few words. In New York, I'm making now 6 very large condominiums. And when my developers, my clients go to the bank, they scrutinize the actual visual design, meaning they look at design, the aesthetics, as whether it's risky or not. Do you do that here in Russia? You understand the question? You understand?
Of course, I do understand your question, and judging by the response of other colleagues in the room, of course, our Russian banks do not evaluate the aesthetic dimension of the construction projects. We only deal with the scrutinizing the documents, and aesthetic dimension has no effect on the decision making. However, for St. Petersburg, that would have been quite an important thing.
Because I'll give you an interesting story. I'm doing right now in Manhattan and Chelsea, 27-story condominium. It comprised of 220 apartments. And the developer had trouble getting loans from the bank because the building looks quite radical. So there was a fear, isn't that funny? So there was a fear that the developer would have trouble selling the condominiums. The only way they managed to get the loan, which was around 150 million US, was to bring consultants to the bank, and one of the consultants is the largest real estate sales company in United States, Douglas Elliman, to convince the bank that this not only would be very saleable, but it would probably sell extremely quickly. So they had to actually go to the bank several times with several consultants. So this is not a typical, let's say, protocol in Russia. No? Okay. That's all I wanted to say.
Коллеги, есть вопросы к Ольге?
Any questions to Olga? Of course, I will disappoint you probably, but the answer is no to your question whether there is such a protocol, whatever. So recently, during the last 2 years, the St. Petersburg developers and developers from Moscow face a problem which is quite huge. It's a tax-related problem during the construction of the socially significant projects. It's not the single problem that arises in the course of the construction projects, and the lawyers also participate in the process of tax planning. Hence, we asked Dmitry Babiner to share the major problems and the potential solutions. Thank you very much. I think we can use this forum to attract attention of those who engage in different investment projects, or projects where there are there's no state funding at all, where the developer just transfers the finished project to the state, so it has to parts of such projects require attention from the state and from the developer's perspective. So Victoria mentioned that this practice exists in Moscow. In some other regions, probably it became extremely topical for St. Petersburg when the regional authorities are requiring, in the inverted commas, they cannot just force the developer to build a socially significant project, but kindergarten schools and other projects of this kind, it's not just a single request, it's a kind of a mass policy. The problem here lies in that is a little bit less than 38% of additional costs incurred by the developer. This is they cannot be put in the cost section because it's kind of the free selling. So for them it's capex plus 38%, and they could not compensate VAT. So there's a palliative measure to resolve this issue in Moscow, because there are more land plots in the state ownership, and when the land plot is provided for the developer, there is a kind of two-way road, and the developer in turn builds some socially significant projects. In St. Petersburg, where just all the free land is private, so there is this is not a two-way road, and there is nothing in return from the state. So when the developers faced this problem when all the agreements have been signed and the construction projects finalized and are being transferred to the state. So the easiest way is to change the federal tax legislation, and just there were some efforts to do that, which did not entail any solution. Just one way is not to change the federal tax legislation or structure such projects through PPP schemes, where at least part of the construction at the regional level, the investment funds are in place, so the state could have picked up the major costs, or just the investor could have picked up the major costs. So this kind of relationship between the government and the investor would not entail an increase in the capex up to 38%. Like I said, this is to give a single example. Sberbank representative spoke, and we work with on project financing with many Russian banks. It's not only the loan from the bank, but it's equity. So it's 3-to-1 ratio if it's not maintained. So most the project is financed by the loan. The shareholders does not qualify it as an expense, which is quite reasonable because the stakeholder has a percentage of profit, not in the form of dividend. But when the same rule is applied to the bank funding, then some economic logic of this approach is lost. So, and just great efforts are made in order to get this message across to the finance ministry. So far they failed to see this difference between the equity funding and the bank loan funding. Bank loan funding in a situation when you request either surety or collateral from shareholders, not specifically foreign investors, but there might be Russian investors who are affiliated with the foreign counterparts, not a quasi-foreign structures backed up by the Russian group. We're speaking about major projects with a major presence of foreign investors. So this is number two problem. Problem number three that the market is increasingly facing now. We'll see a string of arbitration cases because of the norm that appeared in the tax regulation. If the state provides a subsidy to fund this or that project, the VAT, so it cannot, the VAT it cannot be compensated for. So before it entered into force, this norm was not envisaged. Problem two is, even if we, what is federal subsidy? We have to define it. So tax authorities interpret the monies that the regional authorities get in the framework of the regional special purpose programs and just channel to the investors. The federal tax authority is also qualified as a subsidy. For example, through concession or other agreements, it can be also channeled to the investor. So the question is whether you can qualify it as a public state subsidy or not. So it's for the consultants to sort it out. However, it would have been more effective, which is considerable money, about 12 to 18%. Is dozens of billion of rubles. We need to have more clarity in definitions and tax regulation norms on behalf of the state, because we need clarity and transparency, so we could structure the projects to take these norms on board. It's not a question of these norms being bad or good, so we have to just ensure the enforcement. So if we speak about the investment in agreements that are not concession, not qualified within the concession law, so then another problem is to qualify the payment that the investor gets from the state in the framework of these projects. As a rule, the High Arbitration Court's position, it's a mixed type of agreement, not a pure investment agreement. That can be a preliminary purchase agreement or construction contract or services contract. When civilists work on building such contracts and finances, we have a payment which is in line with the civil law, and just rate of return is ensured, and then the tax question is how we split the single payment between the services and the contract itself. It's not a question of legislation, but the question of structuring PPP agreements rather, so that all these legal and financial and tax related issues were well balanced and taken care of. So these are the major tax related problems for major construction projects.
Thank you. This is an important issue, especially considering that we are to celebrate, to mark the 10 years of the adoption of Federal Law 214. And I have been working in my company for over 12 years. We have gone through all kinds of contracts related to sales. We were under 214, we were selling under investment agreements, going back to the new 214 law, and now we have the resolution, which resolution 54, which basically blew up the entire scene, the entire environment, and it's all about the investment projects and qualification of investment projects. I would like to ask Roman Bevzenko to speak a little bit more about it. Colleagues, thank you. Thank you, Victoria, for giving me the floor. Well, the legal position that the Supreme Court has taken, the one that was verbalized in 2011, seemed like a very radical decision at the time. Even legal terrorism, that was the kind of words that were used. But I don't think that There was nothing new that was formulated there. There were quite evident and obvious things written down, everything that was quite obvious for a qualified lawyer, that yes, we can have sales agreements under which you undertake to sell you something that I will build in 2 years. And if I don't perform on my obligations, you will do whatever is written in the contract. So there's nothing new. It's all simple. However, I'd like to speak in more detail about the following: the specific two elements which I believe are inherent to any construction project. And since I'm not only a practitioner, but I'm also here representing academia, I'd like to discuss this from these two standpoints. I think we can differentiate here the relationship between the builder, the construction company, and the person who buys the apartment, and the relationship between the developer and the owner of the land plot. It's possibly quite symbolic that we work alongside several other sessions surrounding us from both sides, and we hear material law and law of obligations on both sides of us. In a way, we are here at the peak of the iceberg, because material law and the law of obligations are the two issues that are very interrelated when it comes to the construction project. Okay, let's talk about a buyer-builder relationships. So what kind of relationship are we talking here about? I received my education in Russia. Russia, with its continental law, I think we're buying about the sales agreement, sales contract. I, as a builder, commit to build and sell, you commit to pay money, and this is a sales agreement, this is a sales contract. And the laws on investment activities and weird laws on various aspects of construction, they do not change anything. So equity participation, individual share, that has nothing to do with the sales contract. But it seems that Russian lawyers have forgotten about it. In fact, it would seem that they forgot about it back in the 90s. However, there may be other reasons of a more systemic nature, but I think for some reason there was this idea that if there is a participating stake in the building, in the construction project, then it's not a sales contract. It's like people give money as a share, and since you invested this money, this is your share. And this is what led to this strange practice and strange discussions of situations so that when the developer went bankrupt, this share that I invested in, this is my share, right? I can go to court and say that this is they owe me a share. 1/356th of a 40-story apartment building. So what does that mean? It means that if there is a conflict, and my banking colleague would agree with me, I think she will support me here, if there is a conflict and the developer is bankrupt, well, if the developer is not bankrupt, there's nothing to discuss. Things are quite simple. And lawyers are not even required here. Lawyers are there when there is a conflict. So if there's a bankruptcy, if there is a conflict, then there is a big fight for the remains of this construction site. Who is going to fight for this, the assets? Those who gave the loan, those who invested, and these individual investors who gave money as a participating stake. So they will be there in protecting their interests, and I'm not going to go into the special legislation on bankruptcy. It would seem that, thank God, this particular developer bankruptcy law supported the idea of the High Court of Arbitration, that people who enter into agreements, and the law says that whatever these agreements are called, preliminary agreements, equity participation agreements, etc. In any case, it doesn't matter. For the lawyers, it means one simple thing. Whatever contract the client enters into, if the client pays money and you will have to give an apartment or some premises to the client, then there's no share in the equity. It may be not so good for the protection of interests of people who invest into such developing projects. It's like a joke, the US joke about shareholders and developers. Shareholders are naive people who think that they have rights for dividends. So these poor people who invested money into the development project, they're also quite naive in investing. We have to provide for an opportunity for people, so that people who invest were somehow part of this whole project, and that if the developer changed, then these other small investors would stay with the project anyway. And this is something that the material law session is discussing as we speak. There's a rule for the privileged right of purchase. I think if our government were to do something good for the people, this is exactly what they would have to do. We could tell the people and say, you know what, in law 214 is wrong. It actually tells you lies, because whatever it says about your individual share in the equity, you just have a sales contract. If you have a citizen and an apartment, then the developer should have an additional element in the contract that if the developer goes bankrupt, the rights of people who invested into this construction would not be void and would be protected, so that they could have a claim for an apartment. I remember I participated in the discussion of one of the deals on buying real estate in a building which was being built. It was in a different jurisdiction, and I was pleasantly surprised to find that the interests of a person who wanted to invest into a real estate that was still under construction were protected. If someone wants to invest, then the rights are protected if the developer has the ownership of the land plot. This is exactly what it is being done for. If the developer goes bankrupt, the land plot will be owned by people who invested into this development project. It is theirs. Now, the second element which I wanted to touch upon, and I will be very brief here, is the relationship between, well, let me go back. When we have a buyer and a developer, we can use different methods, we can use different approaches to the contract. And the same is true about the developer relations with the land plot owner. I asked many of my colleagues about the banks and what they do in order to protect themselves against risks. And the answer was no way. There's no way to protect the banks. There's no legal mechanism. If you have a lease, then there's no way to protect the bank. And I think there is a new mechanism that is being discussed, which is an old instrument, in fact. It's the building tenancy. It was in place before the First World War. Then, of course, it was abolished. And now people started discussing that it might be a good idea. And I keep saying from lawyers, from construction companies, saying that we don't really need it. How is that you don't need it? It's your material right for the land plot. It's the right that cannot be abolished. You cannot abolish this right if you did not make some payments, or if you were late with payments. If you own a plot of land which has a building lease to go with it, then it actually helps you. So if you have a plot of land with the building tenancy, can be the most important asset of a construction company that wants to get bank funding, bank financing. Because the higher the risks are, the higher the interest rates are. It's clear. The lower the risks are, the lower the interest rate should be. So I understand the difference between the loan interest rates with the difference between the ownership and the lease, when you get different interest rates in case your plot of land is in your ownership and when you lease it. It's true. So it's all about liquidity. I think it's an interesting new option. And I think session number 1 should discuss this in more details, but I think that we have to agree that this is a very interesting and very useful option that definitely needs to be discussed at least and adopted in Russia. I think it could help to resolve a number of issues related to investment in construction projects. I have a question for you. So, okay, if you have a building lease, if you have a right to build together with the ownership of the land, if you include people who have a share into this ownership, okay, the question is, how's that aligned? How's that harmonized? And then what happens if one of these people who invested money, if something happened to this person? Well, you see, I use this example just as a case to explain how different other jurisdictions resolve these very sensitive issues. When a developer takes money from individuals, it's okay. It can be okay if you have 6 households, if you have a small house, even if the developer goes bankrupt, there's a competition, but the plot of land remains. It still is in the ownership of those people who invested money, and the building is a risk. But of course, in our environment, in our case, we have a different situation. If the developer is bankrupt, then the plot of land would be burdened with the privileged right of individual persons who invested money. And if there's any way to take on this plot of land and finish the construction, and actually this is exactly what is happening today, but these are not legal mechanisms. It's the governor who sometimes invites over some construction companies and says, well, why don't you do this? And I will agree with some authorities that they will allow you to increase the number of floors. You will finish this construction site and you will sell this apartment, but we will agree to increase number of floors in this house, let's say plus 10. So it's not a legal mechanism. I think this right of privileged purchase is the right that goes together with the plot of land. And you get this plot of land together with this right. If you want to finish this site, if you want to finish this building, you will be easily resolving problems of all these individual investors. No problems there. In fact, if you give me 2 hours, a marker and a piece of paper, I would be able to explain how all these issues could be tackled and how all these answers have already been found, not in this country. It's just that we need to select these answers and prove that these are the right answers. And we can build a good picture that it would be quite clear, a picture where you would not have to guess. Do you have any rights? if you invested. When do you get this right of ownership? When the building was only started, when it was finished, etc. This is exactly what is happening today. Well, I can see that this is a law of obligations. Yes, exactly. I believe that it is important to find this protection. And whether it is the right for the plot of land or the right to finish the construction, I think it's an illusion, really. If we're talking about an apartment block with 1,000 of apartments, it's difficult to settle this idea. It is difficult to agree between these people. Well, then why don't you say it all openly? You are buyers, not investors. It's like when you go and buy an expensive car. You bought a Porsche car. You paid 4 million rubles, which is what a one-room apartment would cost in St. Petersburg. You spent 4.5 million rubles. The car is already here. It's already in the dealership, and then the dealership goes bankrupt. And then you say, well, I've already paid for this car. And say, no, sorry. You are one of the people who spent the money. But why should it be different with construction? You have to tell people, yes, you bought it. No, the social significance. The social significance is one thing, the legal aspect is a different thing. When it comes to social issues, we have to understand that it's up to the legislator. The legislator, and this is something that session number 1 tackles today, needs to ask people, ask the developers, do they want to raise money among the individual investors? If they don't want, let them not do that. Let them raise money with the banks, with the companies, etc. But our legislator says, let's treat everyone as adults. Information should be clear, information should be open, that's true. But you have to understand that if you invest and the developer goes bankrupt, you're not going to get anything. You will be in line together with other people that the developer owes money to. You have to be adults. Well, okay. This is exactly what we can tell our clients, and this is exactly what we tell our clients, that even an insurance is not a guarantee, and that under law 214 you only have a registration. There's no positive side of this new law. There's nothing new about this law compared to the law version of 10 years ago. Well, we talked here about investment contracts, we talked about construction sites that are still under development, etc. But the question arises, what's going to happen next? What will happen to registration of real estate ownership? Well, if you have a contract, which is called an investment contract, and then it actually says, in accordance with this investment contract, the investor has to pay, say, 100 rubles. And the developer, the recipient of investment, which sounds awful in Russian, the recipient of investment is supposed to give a certain real estate in his ownership at some point in time. This is a sales agreement. This is a sales contract. And it's not what we're saying, don't ever get into investment contracts, only enter into sales contracts. But the thing is that lawyers don't work with the words, they work with the meaning behind the words. It may be an investment contract by title, but this is something that you buy and something that the developer sells. It is quite possible that there were other types of contracts. Well, you may have other titles. The real investment contract means that you, for example, invest into, I don't know, plaster work on the facade, and then I get 3 apartments in return. That's a different type of thing. It's all about qualification. It's all about what lawyers do on an everyday basis. It's also about insurance. Actually, the ownership is a more difficult issue here. I think that there is something behind it. This is what, in material law, is treated in a different way. And of course, we can say that Russia is the place where elephants live. We can reinvent the wheel, but there is still a principle which is contained in the continental law. What is built on land is in the interest of people who own this land. So before the developer registers the transfer of title to the investor doesn't have any material rights. And this is why the bankruptcy law says that if the developer goes bankrupt, whatever the developer built, even with the money of other people, and this is not something I came up with, this is something that we have in the law.
Igor Chumachenko, Rigoslex legal firm. A comment related to Roman's comments, which are very interesting to hear always, just in terms of polemizing a little bit. So you shouldn't pay everything in black and white. The sphere of construction and just the ugly phenomenon such as Federal Law 214, there were some good reasons for it. It was not made up by the developers. This law was very important and necessary. The provisions mostly related to the possibility to register the title of property for the share holder, but the developer really seeks to build and sell without registering the title itself. Just a trick played in relation to investment contracts. And just there are still problems related to that. Even in Moscow, if you pay it and just you sell to the city, it's not a purchase agreement. No, of course not. And this is not spelled out in the document we are discussing. What is spelled out there is, but from your comment, we could have inferred that all the types of contracts are well regulated. No, I couldn't have said that, because I do realize that there are contracts that are mentioned and not mentioned in the law. There are those that are mentioned that are not regulated in the same time. So in the civil law, it's a principle of the freedom of contract. Yeah, we support it. What I didn't mean to say was that it's black and white, 1, 2, 3. So if you come up with something which does not fall neatly and with this qualification, so this is a purchase contract rather, if you give me a property and just register the right. But I would like to respond to your comment as well. You pushed me to provide an answer to the question why such ugly, and I'm not ashamed to say ugly, structures of the share funding for such construction projects. From the legal perspective, for a long time, we were afraid to go beyond the dogmatic norms that in the purchase agreement the subject might be something that does not exist. If we go out into the street and just stop 10 lawyers and ask them whether you can have a purchase agreement for something that does not exist, some of them, about 6, 7 out of 10, will say that no, it is not possible. But how do you know that this is so? Another thing is that back in the 1990s, if we qualified it as a purchase agreement, then the code, before the 1st of March 2013, the state registration was mandatory. But how you can do it, because because there was kind of a legal shamanism, and it was somehow reflected in the law 214. If we say, if we call it a different thing, we will qualify it differently. Yes, we have problems with the primary registration. The developer, how the proprietary right for the project under construction exists. People who developed this legislation said that we did have the idea that the developer puts its in the commissions and his rights are registered, and then just the right transfer is registered. Yes, but you had to pay a duty about 7.7 thousand rubles. So then all the flats will be more expensive by 7,000 rubles. Then just the Ministry of Finance, we never just register that, and then they decided to register it on those who just provide this funding for the construction, the shareholders. So they introduced this funny paradigm, and I don't understand how I can enter an agreement. I have to transfer title, and just you have this title registered, but I don't understand that. Maybe I lack imagination, but when I don't understand that, and some other lawyers don't understand that, that means that this just magicians that come to the general jurisdiction law and admit it. But in the 74th plenum was not mentioned that if the developer rejects the right to register the title, because colleagues, there is a code and there is a system. If I'm party to an agreement and I'm not fulfilling, so I have two major aftermaths. Our colleagues are discussing them in the next room. So you choose a scenario. If you can put a claim under just Law 98, he can do it. So if only 3 stories after 25 stories a bit, you just claim the damages. Maybe I was carried away. Yes, thank you. So the most important thing is to have a certain procedure, scenario, and stick to it. Then Igor, in his turn, spoke about the problem of proving this is the kind of the subject of the major construction projects. There were some documents that were released recently, liberalizing your position. What do you think about it? Yes, I can support you in that. The famous case, Sochi market versus the city of Sochi. And this and that number. So just this is a nice number of the case, and it was a reason to, of course, for the presidium review of that, which is a joke, of course. The Sochi market case was a story where there was a contract, where the subject of the contract was very vaguely determined. There were some plans to reconstruct and renovate such trade center. There was design project documentation ready, and then just one of the party claimed the agreement unconcluded, and they say that you could not challenge this contract because a lot depended on you. And our colleague in the second roundtable are just discussing as to PEL concept. Now this is exactly what you're talking about. It's such a vibrant and just very interesting presentation as usual. So now I would like to turn the floor over to Olga Kudryavtseva. So our construction legislation is actively evolving. We're in for a civil law reform. So what the consultants think about this having repercussions for the investment and construction projects? Be brief, please. Yes, I'll at least try to. Good afternoon, dear colleagues. I would like to welcome you here on behalf of our company and just share some practical things that are related to some new changes introduced to the land legislation. A lot has been said today about the construction projects. We understand that each construction project starts off with a land plot, and just you ensure the purchase or title for that. So this is a key issue for construction projects. I'll cover the changes that came into force from the March and April. It's a big package of changes, which is a major reform of the land legislation in the last 13 years. Since we're pressed for time and there are so many changes to cover, I'll focus on two major issues related to the purchasing of title to the public lands and the lease related scheme. There were some changes also, to inform you briefly, related to the easement and reallocation of land basing on the private and versus public lands. Very important issues. However, for time reasons, we'll focus on the first two ones. The first one is just related in the procedure of purchasing and rights of purchasing of the public land plots title. And the major change was that all the land plots are provided through the auctions. So non-auction purchase procedures that were established previously and were regulated by the regional legislation, and those who dealt with St. Petersburg-based projects know that there is St. Petersburg city regulations, and there was an opportunity to get it on the reasons of the special purpose beyond the auction. There are no such possibilities now, so the regional authorities cannot create additional reasons for providing land plots beyond the auction procedure. So today, in all fairness, we need to say that there is the approval that you have to go through the formal procedure of approving the location of land. However, the major new principle is getting land title through the auction. So the pre-approval method that was in place before did not guarantee that you would get this land plot beyond the auction, because the court practice supported those who, having got information about the auction in the mass media, they filed a claim for such land plot, and as they just basically ruined the plans for developers of getting this or that plot of land, and we ended up having an auction anyway. So the land code established the closed list of cases where the land can be provided beyond the auction scheme. So to the one is exclusive privatization right, and the second is providing land for integrated land development to the person who entered a contract for the further development of the territory and for social and other utility development purposes. They're all spelled out in the land code, and this is a closed list as of now. Now a few words about the auction procedure itself. New legislation, with few exceptions, prohibits selling land plots for construction purposes. One can only lease them. And I think such a solution is targeted at tightening control over the activity of construction companies. The talk and discussions about the developers' rights that are now the subject of other roundtable discussions were kind of ignored in the land area, and the other critical issues related to auction procedure. We have just a unified and established procedure for both residential and non-residential properties, which is a new thing as well. Only auctions, not even just kind of tenders, especially if we speak about the public lands. There was a register of the non-bona fide participants of the auctions who won the auction once but never concluded an agreement. I think we can only welcome this decision. And there is regulations about the e-auction formats that will be in force after the federal regulation is adopted. So we have this format for auctions. I would recommend you to focus on the transition period provisions that are spelled in this document. So if the decision was taken before the 1st of March 2015, when these amendments, changes were in force without an auction procedure, you're entitled to get this land plot beyond the auction scheme. Also, a few words about the use of the leased public land plots. Threshold norms, the limits on the periods of lease. So if it is provided for reconstruction and construction purposes without the tender, so the lease period is between 3 to 10 years. Or if you conclude this agreement through the auction, it will double the normative period, which has to be established by the authorities, so from 5 to 49 years. So these restrictions also entail problems for developers in their construction plans. Another thing to mention is that the land code also spells out that introducing changes to the lease agreement as a result of the auction is prohibited. So you can face the situation when, for example, you received it for operation purposes, and the owner of the property on this land wants to reconstruct or rebuild it, and he needs to introduce changes to the lease agreement accordingly, so that such a renovation or reconstruction opportunity can arise. In Moscow, and many people who carried out their projects in Moscow, the Department on Land Resources had an option of introducing amendments to the already existing lease agreement, so that the owner of the venue or the lessee could start such reconstruction. The higher arbitration court practice ruled that this is not possible to introduce amendments in such a way. This is an open question still, what we should do, how the construction can be carried out on the land plot that was provided for operation purposes, or just introduce changes to the established use. So the preemptive right of the lessee for renewing the lease for a new period, which is important for developers. As to other changes, it's about the procedure of introducing easements. Easement can be established not only by the property owner, but by the legal holder. Not only the property owner can sign it, but the lease provider or the person who has this in lease in the for the unlimited period. So there are opportunities opening in terms of the construction or reconstruction of these buildings because such a regime of the constant and unlimited use regime impedes the freedom of ownership, freedom of managing and use. However, now we have the possibility of entering the easement contracts.
So in the past, we had to go through a special procedure to deny the right of long-term use, and then the plot of land became public ownership, and only then, through the sales procedure or any other procedure, the plot of land could be passed over to the investor. These are my brief comments with regard to the innovations that we looked at and that will be put in force very soon. And if you have any questions, I would be happy to answer them. I think it will be very interesting to live in 2015 and especially in 2016. As I said at the beginning, we wanted to add a non-legal perspective to our legal discussions, and this is why we invited a designer, an architect, Karim Rashid. He has a very brief presentation about what an architect thinks about construction in other countries, not in Russia, because our discussion mostly focused on Russia today. So the floor is yours.
Thank you. I have to say, I have trouble sitting usually in front of my own lawyer in New York for 30 minutes, let alone to sit in front of a lot of lawyers for 3 hours. But with that said, I learned quite a few things here, and I just have a couple of comments. It's interesting how the academic gentleman that was sitting there left, and spoke the most. But what he was talking about is what actually happens in the United States, where when you buy in property, you actually take a certain percentage of the plot of land and the condominium. So if there's a bankruptcy, you actually own that percentage post. So it's really kind of very similar to American law is what he's interested in doing, I think, or active in. I don't know a lot about law. I know that in 30 years, just to give you a brief, before I start, I'm only here because I have to thank Etalon Group, who's, as we know, one of the leading and one of the largest residential developers in the world. And I think and in St. Petersburg, we see many of their projects. So thank you, Victoria and Etalon Group, for inviting me here. I've been practicing as a designer for 30 years, and I'm presently working in 41 countries. And my let's say my axiom, my body of work is everything what I call micro to macro. So I'll give you an example. I'm making a mobile phone right now in Tel Aviv. I'm making refrigerators for LG Electronics in Korea. I'm making condominiums in New York, Latvia, Japan, Malaysia. I'm making hotels, designing hotels around the world. I design a lot of furniture and products for Swedish, Finnish, Germans, kitchens for Italians. So I'm quite broad in my work. So this is a bit of a recess, I think, for you now after all this, to talk about something that's kind of more than visual, that's really a part of our physical daily experiences. And what all these when I hear about all this kind of legal discourse, at the end of the day, what it should or adds up to in a way is really one is to disrupt conflict, in other words, create peace, as someone mentioned but also I think that's what the agenda of design in a way, is to create just a kind of easier and simpler and better experience. That really design, for me, is a social discourse, and it's obviously it's a creative act, but it's also an economic act. It's also it's a political act and it's a social act, meaning that we start to shape social human behaviors through this built environment that we create. And just to speak about some of the experiences around the world when I talk about that, is that there's obviously that the world is shrinking, and it's something I think about on a daily basis, is that I read a week ago an interesting article about how we're spending 7.5 hours on screens a day, which is almost half of our waking day, which means that the physical world is playing less and less of a role, because we're having more heightened experiences in this digital age, and the physical world, in a sense, is not moving to the same, let's say, speed and inertia and flux of the digital age. So as a designer, as an architect, what our agenda is, and my agenda really is to kind of make a built environment that is catching up to the digital age. In other words, that there isn't really a disconnect between the digital and the physical. So I'll give you a good example of that is that a domestic environment today, like a home, we build condominiums, let's say, as Etalon's doing. If you build condominiums today and you build them for more of the younger culture or youth culture, or even entry-level apartments for young couples or single people, there's certain trends that are affecting the way the world is moving. And when I say trends, it's not even trends, it's really movements that are not going to go back. We're not going to regress. This is progress. And those trends could be of many things. A good trend, for example, in the condominium world in the United States and in several other countries is that there's a very high divorce rate, extremely high divorce rate, and there's a very high single occupancy of apartments. So for example, in New York, they tried to pass legislation to create micro apartments, meaning building condominiums that would be of 150 square meters, 180 square meters, 200 square meters. The minimum you can build in New York right now is 300, square feet. So 18 square meters, 15 square meters. The minimum you can build in New York is 35 square meter apartment. So I'm a part of that group of trying to make change for this, because we know in places like, for example, Tokyo, that by law, the minimum apartment one can build is actually 8 square meters. So, and this is a trend of people that are living alone and young, et cetera. The other trend that I noticed in the work that I'm doing around the world, because I'm making right now a large condominium in Nagoya, Japan, as well as one in Malaysia, and several in Miami, and 6 buildings in New York. There's a similar trend going on. And the trend is to kind of start to create domestic environments and apartments that are at a better kind of entry-level price point, meaning that there's this kind of notion in most cities that there's a split between really poor, relatively so-called social housing, and then there is luxury. But there's that kind of missing middle market, and that middle market is actually very easy to achieve. And what I notice is that a lot of developers that I work with, there's a tendency that as soon as they start to imbue or embrace the subject of design, meaning, for example, they have a famous name that's attached to the branding of the building, or that they're doing something that's more progressive, then there's a tendency they want to call it luxury. And the reason, of course, they want to call it luxury is to capitalize on the prices that they can receive for the apartments. But some developers come along, like a developer I'm working with in New York, where we're building 4 buildings that are very, very high designed, but very inexpensive to buy. And it's a new phenomena, and I think 200 under construction right now. I think once they're done, people will see something very, very different. What the difference is these apartments are acknowledging this digital age I talked about earlier. So for example, the entire apartment is technological, meaning that you more or less move and navigate through the whole apartment using your mobile phone or your fingerprint. You know, so there's not even really locks on doors, it's all touch, and everything kind of works with the way youth culture and all of us in this digital age are actually interfacing our technology, let's say. That's number one. The second part is to look at these kind of condominiums as that they become more about community, meaning that the community parts of the buildings are more, how can I say, there's more community parts and there's more social activity based on a lot of, because if you live in a small apartment, you spend less time wanting to occupy that apartment. So we're doing things on each hallway. For example, on every hallway, there's actually a community room, and there's all diverse different programs where people in these smaller apartments could share all these other activities. So it becomes a kind of new way of actually going around in a very big circle, which is a very human, very natural in humanity, is this notion of gathering and of social groups and of community. So these are kind of the trends. The other big trends I think that are happening is the change of materials, and to start using materials in the built environment in construction. For example, we're doing one building that's created as a modular housing, meaning each apartment is actually built off-site in Pennsylvania and brought in by truck, and then the entire building is stacked. Now, what's good about this, obviously, is it's very economic. You could build like this at $160 a square foot in New York, where nobody's ever built a building really under $300 a square foot in New York. So it's a very advantageous that way. But second of all, these kind of lightweight constructions and new technologies, I think, are critical to starting to shape product and environments that are relative to this digital age I live in. So, for example, I'll give you more examples, is flooring of apartments. Instead of doing kind of typical floors, and I know it's very different in Russia than it is in many other parts of the world. In a lot of parts of the world, the apartments are completely more or less finished when you enter them. Kitchen is there, toilet, floors, walls are all done. So there's all these kind of new and relatively inexpensive, but perception of higher value and actually more designed material that we're embracing in these projects. So you actually walk into an apartment that is actually at a relatively low cost, and yet you're very surprised because it appears like a new kind of luxury, in a sense. So that's kind of the development and the work I've been doing around the world. You know, from a legal point of view, because it's very difficult for me to comment on that, is I spend, you know, I've probably, with 600-700 projects I've worked on in the last 30 years, and as also working right now in 41 countries, it's amazing amount of contracts that we go through. It's amazing. But what I realize is that in a way, across the board, there's a kind of similarity. And the similarity is the fact that everybody, the agenda of the project is that everybody wants to move quickly and move seamlessly. And generally, where we get caught up is in the legalities, not in the process of design or the process of construction or the process of sales, et cetera, et cetera. It's really the legal part. So that's something that I kind of, in a way, somehow try to foreshorten in a lot of my relationships globally. So, you know, from a contractual point of view, it's hard to comment because there's so many people involved. If I'm working in, for example, I just finished a very nice condominium in Latvia. It's made of 27 apartments. I have to be working, obviously, with an AOR, an architect of record locally, which is what we do around the world. But we will also maybe pool in somebody who's a structural engineer from another country, and we may pool in somebody that's a mechanical engineer from another country, et cetera. So it starts to become a relatively kind of complex group of people. Unlike really product development, because when I do something like a mobile phone, which is, you know, a $200-300 million investment, they have an engineer maybe that comes in from Finland, and then they have an R&D department coming from Israel, and et cetera, et cetera. So it's also as involved, if not more involved actually, than doing something like simple construction. Anyway, with all that said, in design, just going back to design, is that I think at the end of the day, the agenda here is, and why I was appreciative that Etalon Group invited me. Hopefully we'll have a mutual relationship where we'll develop some projects together, is to start doing things that are, let's say, less of an insularity. And what I mean by this is that there's a tendency that I see around the world that we think very much kind of culturally myopically, meaning we only kind of look at what we know and what we've done. But the beauty of this digital age that I talked about is this breaking down of boundaries and borders, which are completely disappearing, meaning if we exist digitally, there are no boundaries and borders, and if we exist digitally, the world is one. And with that said, the world is one, then the kind of desires and the needs and the demands also become universal. And the world also has a kind of similarity, let's say, of those needs. which means then that whether you build a condominium here in St. Petersburg or you build a condominium in, I'm doing one in Mexico, in Playa del Carmen in Mexico, or I'm doing it in a building in Chile, that really more or less the same needs and desires are there. Things are not by any means that different. What gets in the way, and I'm sure this gets in the way in the sense of law, is a kind of subjectivity, where people start to believe or have a very myopic view on what people's tastes or sensibilities or needs are. Because in actual fact, they are, at this point in time, very, very universal. So, in other words, very progressive projects could be built globally, anywhere and everywhere. And in fact, if the project is done where the focus is on, and I always say this about design, that the focus is on we as consumers, as people. In other words, design should be focused around people, not about something that's elitist or remote or strictly about style or something that's even incomprehensible. It's about just everyday life. That's what design is. It's a democratic act. If we really focus on doing some really smart, beautiful, intelligent, and relevant design work, then all of a sudden we'll start to see this whole physical world actually change and catch up to this digital age. So that's all I wanted to say. And I want to thank Etalon Group for inviting me. It's a very good, interesting experience for me to sit here. And I just have to comment on one thing. Brand new condominiums, very high-end, luxury that I moved into in New York, we've had terrible sewage problems. And we found out that the capacity of the pipes are not up to speed as what code asked for. So I've been going through a kind of similar legal issue that was brought up at the beginning. Anyway, so thank you, Victoria, for inviting me. Thank you all.
Thank you. Большое спасибо.
Thank you very much. If there are any questions, I would be happy to take them. If there are no questions, then I'll just say that for us, the Etalon Group, it was the first experience of holding a very practically oriented roundtable discussion. We discussed very relevant issues, things that we think about. I believe this is something that we need to keep up. We have to make it a tradition, and I hope that you will participate in these legal forums. There are changes in the legislation, there are new trends in the legislation, and I don't think that we will have run out of work as lawyers here. There will always be things for us to discuss. And then some of the deals get structured. We often feel as if we were designers. Thank you everyone for your participation.